Thank you for being here on this lovely topic that we have going on in New York. Just a little bit about me. I am actually a native to Long Island. I grew up in Setauket and am a Ward Melville graduate. I went to college and law school in Syracuse. I work in Rochester and live in Buffalo, and I'm an avid board member in Albany. My husband's family also owns property in Saranac Lake, so I feel like I have the whole state covered, which is why I'm traveling around trying to spread the message that we are trying to get these recent tenant protection acts repealed, or at best, which is never going to happen, or amended at best, I should say. So what happened in June was that there was a series of bills presented in an omnibus bill, meaning they were all presented together, mostly affecting New York City. There's two parts that will affect Long Island and then the rest of the state, Part G and Part M, which have really shaken up the way that landlord-tenant is being approached in New York State. Basically, it was a complete revision to the RPL and the RPAPL sections 233 as it applied to manufactured home housing, and then the remainder of the RPL as it applied to regular housing, as well as the 700 series of RPAPL, which pretty much from the application phase through the eviction process changed the way we do things from start to finish. So how I factor into this is I am a real estate partner in my firm, and I have all of my clients are investors in properties that they run. So multifamily based industries, seasonal housing, a lot of them. I do represent some people down here. And so the takeaway right away was, oh my goodness, they have literally changed the way that everybody is going to do business here. And it doesn't seem to me that this makes sense for people to own property in New York anymore, especially when you look at down south or out west. The costs and the profit that you can make suddenly look like they've flipped upside down, and New York's going to hurt from this big time. So we activated quickly. And we have groups from Buffalo and Niagara County all the way down to here that are now coming together to realize that New York City and the 5 boroughs had most of the bill that applied to them, and they're fighting this rent control argument. And the rest of us are kind of looking on the fringe like, wait a minute, does that really apply to us? Because rent control hasn't hit us. And that's not really what we're arguing about. We're arguing about the way we do business, the fact that now landlords are handicapped and you can't really run your business like you'd like to. And on the other side of it, from the tenant standpoint, tenants are going to be getting less and less available housing because as landlords squeeze their criteria, tenants are being displaced from housing that they would have otherwise should have been entitled to. So we have created this argument. It's called Unify. Now we're going to let Long Island into this. So we want to say Unify Landlords. It was an upstate mission. And Compassion for Tenants. So we understand that there were some laws that did need to be taken and changed. But we need to fight the right fight around here. We can't have it so that investors don't want to invest in New York anymore. And so we ran an event at Turning Stone Casino outside of Syracuse in September. We were able to get 400 landlords there. And we are working avidly with a lobbyist group out of Albany, Park Strategies, which is Alphonse D'Amato's company, for those of you who don't know. And we are in this fight to change things, because if not, statistical data we've taken shows there will be less landlords, there will be less housing, and these vacancy rates that they speak of that will declare an emergency to get rent control in the state of New York just don't exist, because the vacancy rates, as we argue, are going up, not down. How it affects you most, we are very conscious of the seasonal housing, same as in my Adirondack area, or student housing. We recognize that this is going to handicap the way that people who own property here, real estate brokers, real estate agents do their business, because those are short-term rentals and they don't make sense to be included in this. And we recognize that, which is why it is important for me to make sure Long Island's included in our mission. So for those of you who want to follow or get involved, see me afterwards, or we can talk through Teresa also. What you have in front of you was an initial document that I did for Monroe County Bar Association. So I will touch briefly on Part G, which is the rent control, which is not applicable to Suffolk County right now. And then what I tried to do is give a shot of where the law was how it had worked, and now what the change is. So that big 3-paragraph chart I'm going to go through with you and give you pointers as to here's the law, but really what's the takeaway? So how does this law apply? How does it affect you? The PowerPoint you have, I believe that my secretary sent it down. You really can ignore that. That is old material that has since been updated with all the data. I do have a new PowerPoint that I will certainly make available to everybody in the room. If there's documents you hear me talk about today that you want to take a look at or you haven't heard someone using, I critically have thought about how we had to change leases and the documents and the forms that need to be done in New York to get us from the old law to the new law. I am 100% a believer that that is free knowledge, so I will share anything I talk about. I know that might be crazy from a proprietary standpoint, but I'm really the attorney who is trying to make a change. And so I feel like other attorneys need to know what I've done so that we can share that information to hopefully get across the state some consistency. The biggest takeaway from this law change is the unintended consequences that the legislator never thought about. That each part of what we're going to go through, they did not realize what they were doing. It was a sloppy, thrown together law. We had lobbied before. I was in Albany the day before the tenant association went in and crowd surfed the sergeant at arms. And the legislators there were at, like, oh my goodness, how could tenants behave this way? And yet, when it came down to it, New York City's stand and push on this law was so big that it didn't matter what everybody else was doing. It was going to get passed. So now it's really a mission of looking at the legislators, calling your local delegates, and letting them know this is the unintended consequences of this law. This little bit, if you got a little tweak here, would make it so that it would make sense for the law to exist. We're not arguing that tenants shouldn't have had changes. The law was overwhelmingly in landlords' favor in most situations, but what I'm going to do as I go through this is show you, yeah, it was, but here's now, because of the change, how it hurts tenants more. So that's the legislative overview. The whole underlying point of the change in the law was they found that there was an affordable housing crisis in the state of New York, that there wasn't enough housing so that people who were just basic, hardworking earners could afford their homes. What they found was that 30 to 50% of most people were what were called rent burden, meaning they were going to spend almost all their paycheck on their rents. And so they said because of the shortage of housing, because of the reduction in federal subsidies, and the increased cost in construction, they needed the changes to this law. For purposes of Part G, again, there were 9 bills that were put into place originally. What the timing of this that was interesting is, for most of you, I'm sure you know down here, their rent control laws have always been in place downstate. For the most part, they were always applicable to the 5 boroughs, to Westchester, to Rockland, to Nassau County, and Westchester. What Part G now does is there was a change to the Emergency Protection Tenant Act, and it makes it so that there is no geographical restriction on that rent control. The trigger here is if a city or a locale or a village can look at their statistical data and find that there is 5% or less of available housing for tenants, they can declare a housing emergency. That housing emergency would then apply to housing 6 units or more built 1974 or older. So, with that in mind, how do we get to the point where we opt into rent control? So, as a Rochesterian now, Rochester was the leading one for the most of this law. We kept hearing there's unscrupulous landlords in Rochester. I'd walk into the Capitol and they would say, it's your city. Your city did this because you guys have landlords up there that are running rogue and they're treating tenants badly, and this is why we need to get this changed. And also, your rents are too high for the cities. So we kept hearing that. And Rochester was expected to be the first one to opt into rent control. And the way you go about opting in is you do a study where they create a board, and I've outlined it for you in the materials, but basically in a county that decides they want to look at the data and decide if there is a rent problem, in 30 days after the first declaration of that emergency, they would get a couple of members from representatives of tenants, a couple from property owners, and then 5 public members who have had 5 years experience in at least finance, economics, or housing. And what they're doing is they're looking at statistical data based on that city for, is there truly a rent issue? Is there not enough housing for tenants? No one really knows, though, once they get to that declaration, what happens next. Because the statute, as it's written, is very loose, it's very broad, and it doesn't define anything. So we're kind of waiting. Around the state, to give you an idea of what's happening, Kingston has already started this process of looking into whether there is a housing emergency. That happened about 35 days ago or so. We've heard nothing since then. Albany has taken the first initial steps to state that they are going to start doing this process. And Rochester, be it the one that was supposed to be the first one, has actually behind the scenes, as I'm talking to people, stated maybe we don't have the housing vacancy that we think we do. And I'm going to argue that Part M is driving that. That's the reason why there wasn't a housing emergency, because the block of houses that they're looking at are the ones that are being revitalized in the cities that I'm talking to most of the time. So from an upstate standpoint, economic revitalization and turning over of old buildings that now could be turned into luxury condos or brought back and turned in from a newspaper warehouse to condos or apartments. All of that's been taking place over the last 10 years. And so part of the mission is preserving that economic development. And you will hear Albany, their mission this legislative session in an election year is economic development. Well, we can't get economic development if you stifle our cities from developing. And they all want to argue gentrification. But that gentrification is making our cities safer, and it's making the economic and racial divides go away. So we can continue to argue that the legislature missed the boat on this. They did not understand that New York City, who lacks the space to continue to build and needed the rent controls, shouldn't really apply to the rest of the state. That each individual area doesn't really need rent control, especially when the markets are so good right now and we're anticipating the economic downturn. What are we doing in the state of New York if we go into this? So any questions, and I'm somebody who loves questions, by the way. I love an engaging room. So any questions on the rent control? There's not really much to state right now on it other than it doesn't exist, it doesn't apply. You will know if it applies because it will have to go through this process. And absolutely with 100% certainty, as soon as something happens, every group I speak to, I will push out material to you all and make sure you know exactly what's going on. Okay, so let's move on to Part M, which is, again, the crux of everything we're talking about here. I'm going to talk about it in the order in which it is in the statute so that we can, if you're looking at the statute, you can stay on task with that. The first thing I wanted to talk about was RPL 223B. And this is your warrant of habitability section. And most people aren't necessarily talking about this section yet, but I want to make sure you all understand for your clients, this is a vital section that is going to be useful for tenants to get away with murder in the court system. So let's talk about where it was and then where it is. So this section was your retaliatory eviction section. It used to be that there was a look-back period of 6 months from the time that you either non-renewed a tenant or took them through eviction. And what it did was, if you, during that time period, had a tenant that had reported to a third-party governmental authority, say the Board of Health, for something that was wrong with the apartment, and then chose to evict them, the tenant could use this as an affirmative defense to argue that you were only doing it because of the complaint. I had, in 15 years of practicing, only seen this happen twice. Once, I was representing a tenant, which I rarely do, and it was a situation where squirrels had gotten into an attic and they were digging, and they had dug so far down that the ceiling was basically a soft shell, and there were droppings that were coming down, and the squirrel was coming down, and the family had kids, and the squirrel droppings were actually found in the crib of the kids' bed. And so, number one, we argue not only a constructive eviction, because I told that client, get the heck out of there, you don't need to stay there, but also when the landlord turned around and sued for rent, we argued a retaliatory eviction. And it was a pretty clean-cut case of absolutely, you cannot evict somebody because we reported it to the Board of Health when I've got an infant that's got squirrel pellets on it. I mean, come on. Easy case. Not so easy anymore. That 6-month period has now been extended to 1 year. So from the time period that you want to evict or non-renew somebody, you need to be careful now to look back a full year and see what happened during that tenancy. Then, not only did it take the look-back period and extend it, it has extended the who and the what. So now, all a tenant has to do is report to a landlord or a landlord's agent. It is not just a third-party governmental authority anymore. And the what is now it extends to your warrant of habitability. So basically, any complaints made during the tenancy by that tenant for a period up to a year from the time you want to non-renew or evict a tenant, if there's any maintenance issues that have gone on in that property, it is fair game for the tenant to just walk into court and say, I'm not paying my rent because you didn't do this. Simple as, you didn't fix my toilet. Or, if you want to non-renew them, you have to be very careful of the interplay now between these laws and fair housing laws. Because we all know that on renewals, you don't have to give a tenant a reason in the state of New York for why you don't want to renew. However, in the background is HUD and New York State Division of Human Rights violations, where a tenant can argue, you didn't renew me because of one of these protected classes. And so the interplay becomes really important in these situations. So what do we do with this and how are we advising clients? My takeaway immediately when I read this was, my clients have to arm me with all their maintenance reports in court now. They have to do it. I have to know exactly what that issue in that apartment look like for me to stand up and defend against any potential action that might be brought. So that is exactly what I've told my clients. If you have had something in the last year and you're sending me into an eviction on your behalf, I want every single maintenance report, even if it's the toilet that overflowed. Because when a tenant makes a complaint and they've started to do it, I want to be able to say, okay, Your Honor, so the tenant is bringing up this maintenance issue. One, are they escrowing their rent? Always the answer is no. Even though in New York State you're supposed to escrow rent and not stop paying when there's an issue. Second question is, okay, on what day and what are you complaining about during the tenancy that has caused you not to pay rent? And so when they give me a date and they give me the claim, I can look through those maintenance records really quick, and I've done this already, where I pull it out to the judge and I say, okay, Your Honor, I got what their complaint was. Yes, they did make a complaint. They made a complaint on Tuesday. At Wednesday at 8 a.m., that was fixed. Here's the PO order. Here were the parts ordered. Here's the assent from the tenant signing off that there was no further issues. And guess what? The rest of the maintenance records, yeah, I might have something 6 months later, but there's nothing to show that they re-complained about that same issue again. Closed door. Otherwise, you're going to end up in a situation where the judge puts it down for a hearing and you are unnecessarily wasting your time defending a warrant of habitability claim on something over like a toilet. But that's what this law did. It gives such broad latitude for a tenant to just use it. And keep in mind again, they may use it just for the adjournment, because that process, which used to be 21 to 28 days, is now 58 to 67 days on average is what we're seeing. And now if the tenant can get the benefit of a 14-day adjournment, which they just have to ask for in court now and show an issue of fact, here's your issue of fact. If they can say there's a maintenance issue they didn't attend to and it's a retaliatory eviction, it's a simple slogan that they're going to learn to use. And now they've got another 14 to 21, depending on how irregular a court is, potentially another month adjournment in a property that they don't have to pay rent to you for. Yes.
Can the tenant claim the warranty with habitability, the retaliatory eviction, even where the problem was fixed?
So the question was, can a tenant claim the retaliatory eviction even when the problem is fixed? And the answer is yes, they can always make the claim on an affirmative defense because it's landlord's burden here to prove it's not a retaliatory eviction. But if you don't have the paperwork from your client on day one you're in court, judges are absolutely going to say, well, landlord, you don't have proof that there's not, and so I'm putting it down for a hearing. And that's why I say if you can get your clients to start signing off on the maintenance issue being fixed with their maintenance forms, and you will hear, if you ever look up my name, you will always see what I have called Jamie's ABCDEs. I'm a fair housing consultant also. Always be consistent and document everything. If you don't learn anything else, standardize those forms. Because if you can introduce it as a business record, that this form is used every single time you have a maintenance issue, you're going to be way ahead of the curve and hopefully save yourself that adjournment for a trial. So again, just a quick takeaway and to show, again, the unintended consequence of how a statutory section like this could send landlords into a wasted amount of money and time. RPL 223B2, this extends this to rent increases as well. So if there's an unreasonable rent increase, this look-back period of a year applies. Now, again, with the statute being completely broad and not really telling us what it means, you have to read this section with RPL 226C to determine what's an unreasonable rent increase in the state of New York. And the answer and the takeaway we've gone with is, well, 226C, which are the new notice provisions, require that a landlord give notice if rent is going to increase by 5% or more. So let's say an unreasonable rent increase would be something at 5% or more for this section's purposes. So again, if you are non-renewing somebody because of, increasing someone's rent by more than 5%, you want to make sure that you're careful to know that they could come at you with a retaliatory claim for why you're increasing that rent. And I want to give you guys a snapshot of how the judges in New York State are so untrained and not well versed in this yet. I got a case right at the beginning of July. So this law had gone into effect June 14th. So I was one of the very first court cases that went in under the new laws. I walked into Rochester City Court, walked in front of a judge. It was a non-eviction payment proceeding. My client, however, had a month-to-month tenancy. So he had given notice in April, well before the law changed, that a 3-bedroom apartment was going to increase from $600 a month to $800 a month. The tenant had been there 8 years without any rent increase. And those amounts, I know everybody in the room is like, whoa, cheap, right? So I walk in and the landlord had given the notice that the rent was going to increase. But again, under the new laws, there was no standard for what the notice had to be other than in a month-to-month tenancy, you would have given 30 days notice. I walk up in front of the judge. The judge first thing is, Ms. Kane, this is not right. You didn't give the predicate 90 days notice. And I said, Your Honor, if you read the law, that doesn't go into effect until October 14th. Schooling a judge, first of all, never a good position to be in when you're starting. Second thing she asked me, though, was, okay, as she looked up the law and agreed with me on that point, second thing she said was, why was the rent increase done? And I looked at her and I said, I don't know that factual basis, but I can only surmise that there wasn't a rent increase in 8 years. I do have factual knowledge to say the rest of the building had been renovated, and instead of terminating this tenancy so the landlord could take back the apartment and renovate that unit, he just increased rent to an appropriate level, which is still below value for a 3-bedroom in Rochester. He recognized it was really low to start, and he didn't gouge it to $1,500, which was an appropriate dollar amount now. He just increased it marginally, and it happened to be $200. She did not give me it because I could not, with 100% certainty, prove in a letter what the rent increase was about. That's not the law. That's not written into law anywhere. And it could have been appealable, but to waste my client's money on such a small amount of money, we decided not to. But the takeaway from there, which is an important takeaway, is this section, as it relates to the rent increase, if you're increasing it, make sure your clients have a legitimate, non-discriminatory business reason for doing so. So did they upgrade that apartment? Did you do something where rent was low to start and now you're increasing it over time? When was the last time you had a rent increase in that building? You don't necessarily have to give it in the notice to the tenant, although if it gets traction, I certainly will let you know that. But you do need to have it in your file, and your attorney certainly needs to have it. So the clients need to be giving you that information as to what the amount, why did you increase it by 5% or more? Because again, the takeaway is the judges are not trained, and they're interpreting the law as they see equitably fit. And that's not what we need here. The other takeaway from the judge's perspective is I got a phone call after I did the Monroe County Bar Association program to about 200 attorneys upstate. And I got a call from one of the judges and said, look, we need you to come in here. We need you to train the judges. And I was like, interesting, because that could be gravy for me to train the judges I'm in front of. But what does that say for the county attorney and the state that you rolled out a law that you have no idea how to interpret and no idea how to teach your own judges? And most of you probably got that unified court system memo that went around. If you haven't, you could Google it. It was like a one-page front and back of all the law changes written by the court system. The first thing I'm doing is reading through that, and I turn the back page and I'm like, this is not factually correct. There's mistakes in this. Who drafted this document? And so you got to be careful of the material that's coming out, whether it's coming out from the state, whether it's coming out from the courts, whether it's coming out from Legal Aid Society. Central New York sent out one around the state, and it actually got on Twitter. It went viral, and everybody got it as a trend when this law came out. Monroe County's legal aid just did something, and I sat down with them and I said, you're not right on this. Tenants do not get a 14-day adjournment just because they ask for it. They have to have an issue of fact to get it. And that's why it's so important to educate attorneys to try and get on the same page so that we're all arguing the same things, because beyond the legislative problem here, we have a court problem. There's no consistency between any of the courts in the state of New York on these laws. Your sheriffs are totally lost. They don't know what they're doing. The marshals are operating totally different than the sheriffs are operating. And the more I call around to locales, the more we're finding out people just are confused. This is really confusing because the law doesn't clarify, and we don't have the benefit of legislative history yet with case law or anything like that to determine. So, the takeaway for that. Next page, if you're following on this lovely chart for me, I'm going to touch on 226C. But we need to be cognizant that we are talking about 226C as we're talking about RPL 232B, which is the termination of a month-to-month tenancy. So as of October 14th, the new rule in the state of New York is that if you are outside of New York City, so New York City operates under 232A, we're only talking about outside of New York City here. So the old rule was there was a reciprocal relationship so that either a landlord or a tenant could terminate a month-to-month tenancy on 30 days notice. As of October 14th, that is not the law anymore. The law now is only tenants have that right under 232B going forward. Landlords now have to look to 226C to determine what the time period is to terminate a month-to-month tenancy. So this law came out on June 14th. There was a chapter amendment done on June 20th. The clarification point was for this section in that amendment, for anyone who's following those laws specifically as you read them. What that amendment did was it clarified that these sections and the time period required must be dictated by the accumulated time period the tenant has been in that property. So if a tenant is on a year lease, but prior to that had been a tenant that was on a month-to-month tenancy for 8 years, you're looking at a 9-year span to determine what time period. So it doesn't matter what the last lease was, it doesn't matter how the lease was drafted, it's just the total time period the tenant has been in that property that decides what statutory section you're going to fall into. So if a tenant has been there less than a year, okay, so 364 days or less, landlord still has the right to terminate a tenancy on 30 days notice. Now this brings up the question for a lot of my clients of, should I just do a 364-day lease going forward? And yeah, I mean, if you want to, always do that. And at the end of that time period, you're just going to say to the tenant, I'm non-renewing you in every situation. For the most, which is 365 days up to a day short of 2 years is a 60-day time period. And then if the tenant has resided there for 2 years or more, it's a 90-day notice. So for leases that are a year long to start, most of those leases, if they're constructed well, will have had a notice provision to the tenants to say, at the end of the tenancy, I require 60 days notice of your intent not to renew. Those paragraphs are still okay going forward. I want to make sure everybody's understanding you didn't have to get rid of those notice provisions from the tenant giving the landlord notice. There's a lot of confusion on that point of, is that still okay? What you can't do anymore as a landlord is dictate that if the tenant doesn't give you a predicate notice, that you will take their security deposit and deem it forfeited. That's those sections that come into play here. No longer can you forfeit a security deposit because a tenant doesn't give you required notice under your lease. And again, that goes to the very heart of lease construction, and it's a contract, and it was a bargain and sale document, and the four corners of that document should dictate, and now we're being told no, that's not what you can do by these new statutes. This section also, I want to make sure everybody understands, so it's not just the month-to-month termination, it's also going to be dictating if you are non-renewing a tenant, what the time period you have to give for the non-renewal is. And it also dictates if a landlord's going to increase rent by 5%, equal to 5% or more, this notice has to go out with these notice time periods. And those notices can be as simple as pursuant to section here, this is your notice required under this statute of notice we are non-renewing, or of notice rents going up. Yes?
Does this affect seasonal rentals at all?
So right now, the question is, does this affect seasonal rentals? Right now, these sections apply to all properties. There has not been a carve out for seasonal rentals. And that, again, is, I'm assuming, the first bit of amendment legislation we're going to try and throw through.
If a tenant has been renewed for 4 summers, and that would be 3, 6, 9, 12 months, or let's call it 14 months because it's 3.5 months each time. Does that mean they have to give the 2-year notice? Can they accumulate the time or no?
So the question is, if the tenant has every season come back and re-rented the same property, would they have to give the accumulation of all the time they've been there? I'm going to argue no on that basis if I'm driving that, which is because each season is its own ending, and so each tenancy is its own tenancy in that situation. It's not a continuous tenancy. Again, that has not been challenged yet. There's no case law to drive that. But from a logical standpoint, if I'm coming in to argue that, I'm going to show that there was an explicit termination date. They vacated, and then there was a new tenancy created. So this is intended to be a continuous statute of how long they've been there, never having moved out. Okay, so next section, RPL 227E. This is a new section, although there were certain areas of New York State that had already dealt with this to rule in the opposite. But now landlord has a defined duty to mitigate damages, meaning that when a tenant is evicted or they abandon a property, that landlord does have a right based in the statute to try and re-rent that unit. So it used to be that landlords could in certain locales hold that property out, not re-showing it, knowing that they had a tenant on the hook who had vacated, that they could charge as rent became due or altogether at the end of a lease term. Now this is just stating that you need to put it back in the pool of property that is available for showing. So if it is a 3-bedroom unit, then you are going to show it when someone asks for a 3-bedroom unit. You are going to put it back on the market. All it dictates is that you use custom to reintroduce it as a potential available unit. What you can't do is you can't say that I have A and B units over here that have been open and free to rent for a longer period of time, so I'm going to show A and B before I show the C that just came off eviction. So that's really what it's saying to you, is just make sure that it becomes a part of the pool again that you can do. RPL 227F. This is one of the most offensive sections. Beyond the time frame of the whole eviction process, this is another area that we are looking for an amendment to in the next legislative session. This section is basically stating that no landlord can refuse to rent or offer a lease to a potential tenant on the basis that that tenant was involved in a past proceeding or a landlord-tenant summary proceeding under Article 7 of the RPEPL. The reason why we find this so offensive is not for non-payment proceedings. Everybody recognizes tenants go through hard times, tenant loses job, tenant has a medical issue. What we're seeking to have done potentially is to bifurcate this and have non-payment proceedings and not using the credit history and that, recognizing everybody deserves a second chance. There's the hashtag compassion for tenants, versus those breach of lease situations or egregious behaviors that happen on property where a criminal conviction is not yet rendered, so you would not locate it in a criminal background check, or they've damaged your properties when you're there. To give you, again, I love to give real-time scenarios as to what it is so you can see why it's egregious to someone who's fighting this. I had a situation where I had evicted a tenant who was basically damaging the property and also not paying his rent, but had taken to Facebook to defame my client and stating things like, this person doesn't provide heat and hot water. He created a website about that. And then he would blast the city inspectors, the city controller, the mayor, and everybody else who would listen. There used to be 38 political parties that he would put on these emails about my client. We eventually took it to a defamation lawsuit and won and proceeded because he did have hot water and he did have heat. The problem was he was amputated from the feet down and he was living in a loft. Well, we all know heat rises. So every single time the inspectors would come in, it would register a proper heat, but it felt cold to him. And so we said to him, probably not the best place for you to live. Let's move on. We'll release you out of your lease. We'll give you moving money, and let's find you someplace that's a lot, the ceilings aren't so high and that the heat won't rise so much, and maybe you will feel better. Well, he doesn't do that. Instead, he turns the oven on for his heat and leaves it open and gives himself carbon monoxide poisoning, and now he's accusing my client of murder. So, we eventually evict him. He eventually moves into another property, and we did such a good job for that client that guess who gets the referral for him again? Me. Not fun. So now I'm taking him through a proceeding where he is a Section 8 tenant, and he is trying to contract around that because he got a settlement with my client in the first proceeding for money to move out. He's now using that money as an aside to Section 8, which we all know in the room you cannot do. And he's trying to contract for this property that is over the limit of his voucher, and he's saying he wants to move in. Well, my client feels bad, lets him move in, and he says, I'm a first-time landlord. We'll get to the bottom of this. Move in, take possession. He obviously doesn't have information about the prior eviction, and we will work with you to figure out this Section 8. This client, my next client, is a military member and recognizes eventually that Section 8 does not allow you to contract on the side to pay cash beyond the voucher. He says this, and he says to the tenant, oh my goodness, you need to vacate because you can't live here. I can't lower my rent to the amount of your voucher. That won't cover my costs, and you can't contract, so I need you to vacate. The tenant's like, I'm not going anywhere. Evict me. Again, takes to Facebook. This time, he claims he's dying from cancer at the same time. And so he does an onslaught of Facebook where he's now saying, what should I do to these people? And oh, by the way, he's tagging me, this time the mayor, my client, the former tenant, or former landlord. And he's saying to them, what should I do to these people before I die? Well, that's a death threat. The mayor's office took it as serious. And now you're saying, even if I evict this person, I can't have knowledge that this type of tenant lives in the city of Rochester and other landlords can't get that knowledge that this guy is out there and he's number one, damaging the property. He was taking a hose in the second property he was at and he was flooding it all out because he was angry. So every time this guy got angry, he'd post up on Facebook, he'd make a death threat, he'd do this. All the while, the legal issue was you couldn't pay your rent. You need to get evicted because you're not paying the rent and you can't, in good conscience, pay around Section 8 unless you'd like to lose your voucher, sir. Obviously, that would be stupid because you wouldn't get it back. So the bifurcation to me is so important because landlords have a foreseeable duty to let them, other tenants in their properties, know that there's somebody dangerous on your property. And how do we do that if we can't get a landlord reference from someone else? Because if my client A had been able to share with my client B, it's not that we're creating a blacklist of tenants, we're doing our due diligence. Like any other deal you would do, you're doing your due diligence as to who you're letting in your property. This property that's mine, that's my investment, that's my duty on a liability standpoint to know who's living there so that I don't know that I am harboring somebody who is potentially dangerous to my property or to other persons. And so that's what we're trying to get the legislator to understand is there are scenarios where you need to know who's in your property, and handicapping landlords is not helping anybody. So that's that. We touched on 232B, so unless there's questions, I'm going to move past that. RPL 234 changed the rule for attorney fees. So as it applies now, attorney fees are not able to be asked for and sought and collected unless a tenant appears in court and the court awards it. So it used to be that there were certain courts that if you pled that you did all your due diligence under CPLR 308 as well as RPAPL 735, that even if the tenant defaulted, you would be entitled to your fees, your costs, your judgment, and your attorney fees. Now it is a very strict rule. Unless they appear in court, you cannot get it. And this is something that is with prejudice. So it's not that you can go back into a plenary action like small claims after the fact and ask for the attorney fees from your eviction. You will not get it anymore, where you used to be able to get it in small claims courts or collection proceedings after the fact before this law changed. So that is a change for attorneys. It is another example of the cost to clients that are being incurred. So clients are just losing their shirts because they're not getting things like we're going to go through the application fees and things like that anymore. And now they've got to pay their attorney fees out of pocket without reimbursement. So there's some pushback there. 235E, these are sections now that are codifying the written receipt requirements. These sections originally clients were freaking out about. I think as long as we temper it to a tenant has to ask for these things, people understand better of, okay, I don't have to send out 500 receipts every month. It's a tenant has to very pointedly ask for it. And then most likely the only change is that it needs a signature from the person who is taking in the payment. To show who was taking that rent payment from them. Now, the duty is if they give you the money right away, you're giving them a receipt right away. If it's coming in from an ACH or auto debit, or they're putting it in a mail drop box slot, then it's 15 days from the date you receive it that you have to send a receipt out. It's deemed to be a continuous request, so if they ask for it, every month you should be giving them that receipt. But again, if a tenant doesn't ask for it, it's not something you just have to do on your own. Now let's talk about briefly the predicate requirements to getting into a summary proceeding. So RPL 235ED is a brand new section. I'm going to argue that there are two predicate responsibilities that a landlord has to do or a client has to do before you can take a matter into an eviction going forward. The first is this 5-day late notice. Although I don't know why they call it a 5-day late notice because it has nothing really to do with a 5-day. So I'm going to get rid of that for you and just call it the late notice. So what this section is saying is that you cannot charge a late fee, nor can you do anything about an eviction in terms of giving them notice that you're going to start an eviction until the 6th day of the month. So it has to be through the 5th day, end of business, that they do not pay their rent. And then on the 6th day of the month, you can start your eviction proceedings. The first thing being this certified mailing. Just letting the tenant know that they are late in their payment. Now, the confusing part of this and the confusion of the statute is, how does this interplay with the notice to quit, which used to be a 3-day notice to quit and has now been extended to a 14-day notice to quit? Okay? The first thing is, there's two very different prescribed service methods. The late notice is prescribed to be only served by certified mail. That's it. The 14-day notice to quit, which is giving the tenant the right to cure the rent amount or vacate and quit the apartment, is always been served under RPL 735. It is just codified now to show that it has to be done by personal service, meaning a process server or somebody who's not an interested party should be going out to the property trying to serve that 14-day notice to quit on 3 due diligent attempts, 3 different times of the day. And if you don't get someone personal, but you do get somebody by subservice or by mail and mail, if you have to make that 3rd attempt, that within 1 day of that service, you are following up with a dual mailing requirement of a first-class mail and a certified mail to the situs of the property. Okay? The confusing part of this is the content of what goes into these 2 documents. The late notice is the only thing that states that if you don't give this, it's an affirmative defense to the tenant to raise in court. So this definitively is a document, if you know you're walking into a summary proceeding, that it has to be done. The question is, does it have to be done starting on the 6th day of the month, or can you do the 14-day first, and right before you realize they're not going to pay on the 14-day, send out your certified and go into court just showing you've done it? The answer to that is, sure, it sounds like you can. Reading the statute, there's nothing that says the late notice goes before the 14, or that the 14 goes before the 5. It just says they both have to be done. Case law over time will develop that, hopefully, to tell us, is there a pecking order of which one goes first over the other? But right now, the message is they both have to get done. And no, this is probably the next question, you cannot put them in the same envelope. No, no, no. I got that from clients of, oh, I'll just do my 735 service where even if I get somebody personal, I'll send it certified and I'll be done, and I'll just put the 5-day late notice in that certified mailing and poof, we're done. Only 1 certified mailing needed. No. It is very specific, and every judge I've spoken to is hot on this with no, 2 separate notices, 2 separate envelopes. Now, if you have 2 tenants at a property, can you take a 1 notice, put 2 tenants' names on it, and mail it in 1 envelope? No. Each tenant needs to get its own separate mailing. Okay, you can use the letter. The letter can be addressed to both tenants, but you need to make sure if there's more than 1 tenant that there is a certified mailing going out to both. Because if you look at 735, it's the same what you're doing there. Each tenant gets its own mailing. Each tenant gets its own affidavit of service that it was done to that tenant. And that's the mistakes that I see going on in from the attorney standpoint of people don't necessarily understand what's happening here. Now, as to the content of what the document says, again, we are so blinded, we don't have any direction in the statute as to what it says on the 5-day notice. So we have parts of the state that are itemizing, this is what's owed, broken down into the months. We have parts of the state that are saying, well, this is my 1 chance at the enchilada to get everything that's owed. I'm going to seek rent and additional rent, things like pet fees and utility costs and garage fees. I'm putting that into my late notice. Well, the problem there is on the 14-day notice to quit, your 14-day notice has to match your petition. And if we jump down a couple of sections, RPL 702 now redefines rent to be the base rent for the use and occupancy of that unit only, and that you can't seek anything else in a summary proceeding. So you're never going to get late fees or pet fees or utility costs unless the landlord's directly paying them in a summary proceeding going forward. So your 14-day notice has to be 100% stripped down to your base rent. Yes?
How about attorney's fees? Because you had said not on a default, but now.
You can always ask for them, and I do continue to put them in my petition asking for attorney fees. It's just it won't be given to you if they don't appear in court. But yes.
I thought additional rent then would not be attorney's fees.
So that's another pointer of what do we call attorney fees? And so I've taken that out of my leases in terms of calling it additional rent. Now, judges for the last 5 years have kept hammering on us. If you don't put it in your lease as additional rent, you're not getting it. Now the confusion part is, well, what do you call it? And I've taken it out as it's statutory pursuant to this section. Just defining it as attorney fees awarded under RPL, here you go. Because if we define it incorrectly, we're not necessarily going to even be able to get it when it's in the statute that you're entitled to it if the judge awards it. So yes, continue to ask for it, just stop defining it as additional rent. Which that may change, in the next wind, but that's where we are right now. So again, different parts of the state totally driving and confusing with this 5-day notice. Some people are putting everything in, some people aren't. Now, for the people who are putting everything in, you're mailing out this certified mailing. What we're finding statistical data is 99.9% of tenants are not even picking up this certified mailing, so they have no idea what this predicate notice is. And then they're getting their 14-day just served regularly, and they're curing what that 14-day base rent amount is. And landlord goes into court or if they don't cure it, landlord goes into court basically saying you owe me $700, when in factual allegations based on everything they've contracted to under the lease, they get $1,500 that they owe, and tenants or landlords are out $800, and it's a running ledger. So we've got a problem from that conception of what the 5-day and what the 14-day say. So from the lobbying standpoint, one of the things we're arguing for is get rid of this late notice. Just get rid of it. The whole basis of landlord-tenant is to be at the situs of the property. Why on earth you chose a certified provision makes no sense. No tenant's getting that. No tenant's even looking at that document, and they're not getting the chance to know they're late. But who really gives you a chance to know you're late? Take your mortgages. Do I get the benefit if I'm late by a mortgage document saying, hey, you're late, Miss Kane, with your mortgage? No. It's a contractual obligation. You know when you made rent's due on the 1st. If you don't pay it, you get a late fee. And then if the landlord deems it necessary, they take you to an eviction. We should all be wary of that. I don't think there's any confusion standpoint for tenants on that point. It's always been the way it works. So that's what we're arguing, is to rescind that notice or at least get rid of the certified, because it doesn't make sense. And the interplay between that and another law is real prime here. So for those of you who are unaware of the Fair Debt Collection Practices Act, this is something I've thought about because in my early baby years as a lawyer, I did have to do some collection work for my firm. And I'm sitting here going, how is the least sophisticated consumer, who's supposed to be viewed at as somebody who doesn't have any knowledge base to form an opinion, going to reconcile a 5-day notice that's demanding $2,100 and a 14-day notice that's demanding $1,400? They're going to be confused. They're not going to understand. They may not pay rent at all because they're seeking clarity, which again comes into court as a retaliatory eviction in against landlord. And what are we doing with this? They're always going to pay the least amount if possible. So again, it's a wasted notice on the part of the landlord. And now if I'm the attorney stepping into the shoes of a debt collector trying to collect rent, which is covered under the Fair Debt Collection Practices Act, am I walking into a situation I don't want to be in as an attorney? Because I'm confusing a tenant. So that's, again, I don't think the legislator took the time to look through and see, is there something that they're missing here in the interplay between this and fair housing and fair debt? They're all connected, and this is a can of worms here with how this could go. So as we move into the eviction then, again, stripped down dollar amounts of what you can seek. How do we deal with your ledgers? And how do we reconcile then what's owed? And the way we all used to tell our clients is apply when a payment comes in to the most outstanding debt first. We can't do that anymore because judges are looking at the ledgers, they are taking it and dissecting it, and they're saying, okay, well, they paid $800 in July and rent is $800. Where did you put that $800 to that they now have a running balance? And you might say, oh, well, in June, before the law passed, they had a late fee that they incurred and they didn't pay their storage costs or whatever else it is. So it's a running balance. And I like to tell my clients, no hanging chads. You can't have a hanging chad, as I call it. You can't make it so that you're not applying rent in the current month to an outstanding balance anymore. The judges are tossing it. They want to see allocation to base rent first. So you got to change the way your leases read. I can't tell you how many leases across the state of New York I changed based on this, which is allocation of rent first, then additional rent second. And then critically thinking through, okay, well, these additional rent amounts, is it worth charging a late fee anymore? Because you're basically never going to recover it. Or is it worth charging a pet fee? What do we do with those pet fees? In the manufactured home park world, the Attorney General took a long look at this about 18 months to 2 years ago now, and they didn't like pet fees. I got a call from the AG's office on a manufactured home park, and he said, well, what's your pet fee for? What is this monthly pet fee you're charging? What is your client doing that's providing something for them to charge that? And getting away with saying, well, it's for the privilege of having an animal, not flying with the AG's office. So then, back then, it was critically thinking, okay, well, what are you doing to earn that fee? And so clients of mine set up pet runs, and they provided poop bags, and then the AG's office got comfortable with it. Where it's like, all right, if you could show they're doing that, and you could show that you're doing things for the animal that warrant the fee, okay, fine. It's a cost of doing business to set that pet park up for you to have animals. And so clients of mine had to scramble to do that. But here, you know, what do you do with the pet fee? Again, I think the AG's office has so much power over this law written into a lot of sections that I anticipate the AG's office looking at these and looking at New York leases in general and trying to formulate things that you can't do. You can't charge those fees. So I had created, as a result of the emotional support animal argument, a animal responsibility addendum that now I have written into that if you don't pay your animal fee per month, your right to have the animal will be revoked. And so we've gone in on that with, okay, I'm not seeking rent because of the animal fee. I'm seeking to remove that animal from my property because you're not paying the monthly pet rent. And so it then becomes a situation where it's a breach of an addendum, which is a breach of the lease, which then allows me to go in as a holdover situation when a tenant doesn't remove the animal. Same thing on storage or garage leases. Forget about trying to get them in a summary proceeding. Critically think, how do we get them off there? Well, use New York lien law instead of going ahead and seeking garage rent. Because all that's going to happen is landlords are going to have bad debt at the end of the tenancy that accumulates, and then they've got to make a decision of, do we take them in as small claims? Do I take them to a collection agency, or do we just write off the bad debt? But it's accumulating. So those are key pointers here with these sections that, again, unintended consequences. With a landlord writing off that much bad debt, how much money do we really think they're putting back into their properties? It's going to go down. It's not going to go up. Any questions on that whole eviction section? In a situation where you're doing a holdover, if it's a natural end of the lease, then you don't need to do any other predicate notice. You would just go ahead and file for eviction based on the next, which I'll go into the timeframes in a second, and you just go into court. Same thing with if you're terminating lease prematurely. It's going to be dictated by your lease what that time period looks like. Now, it's a good point, though, to bring up here. Lease terminations, and does your lease still exist for those sections? I have written a lease that was really tight that basically enumerated 25 different defaults, of which if a tenant had defaulted under any of those sections, on 3 days' notice, we could terminate the tenancy and walk into court. A lot of leases are like that. At first glance, we were like, oh no, is that section gone here? Can we not use that anymore going into court? Because it was great. It was a great tool to be able to say, this is objectionable behavior, or this is criminal conduct happening, and get them out. There's one section in the new law that says they have to be able to cure their breaches, and that you have to give them 30 days notice. So some judges have taken to say, well, it has to be a 30-day notice then, because you have to give them notice to cure. Well, no, because I'm going to argue that there's some breaches you cannot cure. I had a horrible situation at one of my properties where there was a rape on property. How does that get cured? You can't cure that. You're going to jail. So you should be able to terminate the lease and get rid of all the items and turn that unit quickly. I shouldn't have to wait 30 days. So it's something that to watch for in terms of case law that it's being established with. Does that section still apply? Can you just terminate your lease still based on the lease clause and move into court? I have not been stopped with that yet. The only thing I have had happen is we brought it in after a 3-day termination, and then the judge said, okay, I'm going to issue a stay, because in that situation it was an unauthorized occupant that was there, and they gave them 30 days on a warrant stay to remove that occupant or face eviction. So I would say no predicate notice at all. Those 5 and the 14-day are strictly for non-payment. You're welcome. All right, so that is those sections. Let's talk about here the timing. So it used to be that you would, for justice courts or town courts, you would serve your eviction papers, and then you would know when the next court date was, and no sooner than 12 days prior, no shorter than 5 days prior, you would serve your papers, file them with the clerk. 3 days before court, get into court, be done. And as long as they were filed within 6 days prior to the court, and at least in some locales, you could usually argue, despite the default, you would be entitled to a warrant and a judgment in court. That was a luxury. Don't know if it existed down here, but it was a luxury upstate in some courts where the judge would entertain. And we had one of our county court judges actually on the record rule that that would be considered good service, and despite the default, you could get both at the same time, which was nice. Now that has been extended from 5 to 12 days to 10 to 17. So already, based on the new 2 predicate notices, you are never going to get an eviction in the same month that the rent is due and owing in. So it used to be that you'd be able to walk in, and within a month, you would be able to get into court and get a warrant. And so again, it would be about a 21 to 28 day cycle from start to finish. Now, those numbers are looking again like 58 to 67 days pushed out. And so for your small business owners, people who own, not a lot of properties, or this is their bread and butter, their mortgage payments are going to be late eventually. They're not able to pay their own amounts. And as these laws extend out, we are seeing that they are actually extending further. I'm going to get into the warrant section and give you an example of what's happening in Albany. They are literally trying to extend this as much as they can. So those time periods are frustrating. Again, irregular courts, it's even harder because courts may not meet more than once or twice in a month. And if you can't get in on 1 month because of the way the cycle is, you may be 2.5 months out before you even get your first look in court. Again, this trial issue under 745 is driving clients crazy, where some judges are not educated enough to know that it's not an automatic adjournment. It is not an adjournment for counsel. That's the other thing I hear all the time. Well, I need an attorney. No, you knew court was here. Now you even have the benefit of more time. Having an adjournment for counsel is not what this statutory section is for. It is intended to be that there is an issue of fact that is between the parties that requires a trial. And again, that is something that is a maximum amount of time, this should say a minimum amount of time. So at a minimum, it's going to be 14 days. That got changed. It must not get changed in this. So a minimum under 745. Sorry, these were printed without it. So a new law allows for a trial to be adjourned for a minimum of 14 days, meaning that if that court doesn't meet for 21 days or 25 days, it's the next regular part, it will get adjourned to that. So again, the time frames just keep getting pushed out. RPPL 749, the warrant service. Again, another legislative section we're trying to push back on and shorten this. It used to be a 72-hour warrant for non-payment or for holdover after court. It is now a 14-day warrant. And that is 14 business days. And the other thing is, it's from sunrise to sunset. So we just changed the clocks back. At 4:50, when it's dark, a sheriff or a marshal now has to stop serving a warrant. When it's dark in the morning, they cannot serve before a certain time. Now it should be better in the morning. But what it did was it shrunk the time period which they can now serve. So immediately upon dark, they have to stop. So in the outlying areas where it's harder for a sheriff to get to, or it's a longer drive and he has to make a one-off concession to go there, you're going to get that warrant served much later than it has been. It's not going to be served timely. And in Albany, what's just happened is there's a case, a tenant sued in the Supreme Court, and what they just said was, well, it's not when the 14 days is served that starts the time frame. It's when the sheriff files the affidavit with the court that 14-day time period starts. And that is crazy because, number one, you don't know when the sheriff has filed it. And number two, what if the sheriff isn't operating under your due diligence time frame and it takes them 3 to 5 days to file that affidavit of service? Now that 14-day warrant in Albany County is a 19-day warrant in Albany County. So hopefully that doesn't extend across the state. But the sheriffs are all over the place here. They don't have any direction at all. The other thing with the warrant, I need to make sure everybody understands this because it's not yet being applied, but this is something written into the law, is the new statutory section states the warrant will only remove the tenant. Well, what about unauthorized occupants? And this is something that the courts now, the judges, I was in Rochester City Court, and the judge there said the warrant shall only apply to the tenant on the record. And the marshal that we use and the sheriffs in the locale are still operating under the warrant shall remove any and all persons. And that's good for us, but it's only a matter of time before the judges enforce the law of the statute. And then what do? So number one, the takeaway here is you got to start telling your clients no more occupants under leases. Everybody over the age of 18 has to be a tenant because of this section. They all need to be rent responsible tenants. And some are like, wait a minute, well, what if someone has bad credit? Well, then you got to figure out a cumulative rental selection criteria where one offsets the other. Because otherwise, what's going to happen is you're going to go through this whole process, be at 58 days, have your sheriff, once this is starting to catch wind and they enforce it, have the sheriff remove the named parties on the lease, and then you're left with 2 unauthorized occupants that you may or may not have been known were living there, and you got to go through the whole process to get them out again. So if you know of any unauthorized occupants, one way we've started getting around that is in the 14-day notice, we make it a 14-day notice and a 10-day notice under 713, subsection 7 and 5, which are your squatter and your licensee theories of here's the notice that's predicate to people who are tenants and are not paying their rent, but here's the notice to your licensees and squatters of your 10-day notice under the RPL section 713, which requires 10 days notice to someone without a landlord-tenant relationship to say, in 10 days, you need to be out or commencing eviction proceedings. And if you get to that point where your process server identifies that, yeah, there's an unauthorized boyfriend there that your tenant failed to tell you was living there, you can go into court and not lose time. The other option is you're going back in and instead of proceeding under a non-payment proceeding, you're proceeding under a breach or a holdover based on a lease violation that your tenant failed to tell you that their boyfriend was living there. So it's one of those two things, but if you can do the 10 and the 14 together, then when you get to your petition, you're naming your tenants, but then you may also know the occupants' names by them to name them, or you're naming them Jane and John Doe, and you're putting in 2 causes of action into your non-payment, or your notice of petition rather, which is cause 1, non-payment for the tenants, cause 2, holdover on 713 grounds after being terminated with a 10-day notice pursuant to RPAPL 713. That way, your warrant can cover all persons in that property. So again, this is a section not yet being used, but be cognizant of it because there's a loophole that wasn't closed by the legislator there. Any questions on that? Okay. Same thing now again with the section here on RPAPL 753. These are new stay provisions. These were never written in before under the old law. And what these sections now do is they enable the court on application from the occupant to stay the warrant for up to a period of 1 year if the court can find that after good faith, the tenant cannot secure other housing that would be suitable or like kind to the tenant, and if they don't grant them the stay, that they will be under a hardship. Okay, so what are some of the things and the takeaways here that we see in determining whether they will grant the stay? Things like, is there a serious health issue going on? Is there a significant exacerbation of an ongoing condition? Is a child enrolled in school? Or is there any other extenuating circumstance? Now, for the purposes of here, outside of the city of New York City, the term neighborhood, so this is any city with 1 million or less, so obviously that is only New York City that would apply to this exception. But here the neighborhood means the same town or the same school district. So it's so easy now for tenants who are in a situation where they have moved into a property to say, well, my kid's in school and it's January, so I need to at least stay until the end of the year. If not, if I can't find something, I might need to stay through next year. And so these, again, are abusive sections that we think that tenants are just going to start using because they're going to gain traction that they can use them. In the situation where I was telling you about the tenant that I had evicted based on the defamation claim, I appeared in court with him and he tried to use this. He tried to use this section to say, wait a minute, judge, I am in housing and I have a serious health concern. I'm dying of cancer. I'm an amputee and I've tried to find other housing. And I said, okay, well, what have you tried to find? And he presented to the court, which obviously I got to look at, 3 different asks of properties. And he said, well, all of them said that they don't take Section 8. Well, in April of last year, in the budget, source of income was codified in the New York State Division of Human Rights law as a protected class. So nobody in the state of New York should be saying you don't take Section 8 anymore. It's source of income protection. So I argued that first. And the judge says, okay, well, let me see what you have. And so he shows documents from a broker and from an advertisement where he had asked if they would accept him as a tenant 2 days prior. Well, I had started the eviction proceedings in April and we're in August. How do you not look for property between that time period? And so luckily we had pulled our own information of available housing and we were able to find not less than 250 apartments that he could rent at his price range. He just didn't want to go to those areas. So takeaway here is arm yourself. Use your brokers. Use your real estate agents. Know what's available as housing. Know whether your dollar amount that the tenant has been under is appropriate. Did they get a steal? So I use Saratoga property as an example all the time. If somebody a landlord was foolish enough to rent a house in Saratoga for $600, good luck getting rid of a tenant here under this statute because nobody is going to be providing a house in Saratoga for $600. So again, to your clients, what is the custom in the area? What is rent going for? If your clients are getting heartstrings and they're giving deals to tenants, which I see all the time, it's not going to help them under this section anymore because they will be too low for the competitive properties. And if those properties are too high for a tenant and a tenant has one of these issues, or if a tenant has an issue with health or a child in school, and they could show there's no available housing for what they're paying right now, you're going to better bet the judges are going to start to give these stay provisions for the warrant. Now, questions I'm anticipating, if there's none in the room, are, well, do they have to pay rent the whole time? Yes, they do, which is a good thing. So in order to get the benefit of the stay, they have to continue to pay the rent as it becomes due. Either the court will require it and monitor it, or they'll have to pay it actually into the court. What they don't have to do, they don't have to cure the back rent. So you will have gone through an eviction, you will have a judgment, per se, against them for the back rent they owe. They will then ask for an order to show cause once the warrant has been awarded, asking for a stay of that warrant. You come back into court and they just have to pay rent going forward. They're never curing the back rent. And if they're staying for a year, they're going to get the benefit of not having to pay on that judgment amount for that year. Now, if they stop paying on their current rent, then it would entitle them to ask, hopefully, for the court to accelerate that warrant, meaning we do an affidavit of default, they haven't paid their current rent, and then they're out. And that is something that you would want to preserve in your stipulation of the order to show cause, to make sure if any missed payment as it becomes due, you have the rights of acceleration so that you don't have to go back through another proceeding. Which brings another point too. In your notices of petition, we all used to say something to the effect of, the warrant language, that you'd be entitled to a judgment through the issuance of a warrant in your petitions. I've modified that language to say through the execution of a warrant, because again, I want to make sure that I'm entitled to rent until that tenant is removed from the property, not just on service of the warrant, which used to void your lease, but now doesn't. There's no void of that lease anymore. It can be reinstated by the courts. So you got to make sure that warrant language is saying through the execution of that warrant. In addition, that crazy 5 and 14 day, there are some judges out there that are saying every single month you have to serve those notices before you get into court. Well, no, you shouldn't have to do that. You just need amendment rights to your petition. So make sure your petitions have language in it that says that the petitioner on motion can move to amend the petition to include rent that becomes due during the inception of the proceeding through the execution of the warrant.
Sorry, can I just switch gears to you a little bit? Sorry. But for me, and I think for a lot of people in this room, the question is, what are we doing about these seasonal leases? Because the way I'm understanding it, we're not allowed to charge rent. And it does tie into evictions, because evictions take so long. And somebody takes a rental for, say, an extended season, 6 months. And the 6 months begin in May and end in September, so whatever 6 months is. So they end up getting the prime season, and they only pay the first month's rent, and then they stop paying, and now the landlord's lost use of the premises. So what is there any workaround? Like, for instance, can you say, I'll charge you $60,000 for the full 6 months monthly, or I'll give you $50,000, or I'll charge you $50,000 if you pay all up front? Can you do a discount?
So the question is, can you put in rental discounts if you pay? Now, the new law states, and this applies, we were going to get there in a second, but it applies to the security deposit section, which says going forward you can only have 1 month's security based on the base rent and no advances of rent. So a landlord cannot ask for that advance, okay? And it used to be practice for screening tool purposes that landlords would take first month's, last month's, and double security deposit. And most often you would see that in situations where a tenant was a marginal tenant, maybe their income wasn't enough or their rent to income ratio didn't meet the landlord's criteria. But you definitely saw it in seasonal where it was, well, I'm giving you my property for a short period of time at a luxury area, which is marketable to you, but it's also marketable to 50 more people who want it, and I want to make sure you're going to secure my property, not do damage, and pay me my rent. And it's a moneymaker for people who have these luxury rentals. And now the legislator has handicapped that. So your Assemblyman, Fred Thiel, is very cognizant of that and is working with my group to put an amendment in place that would clarify seasonal rentals should not apply here. And that is something we're pushing for Long Island, we're pushing for the Adirondacks, we're pushing for wine country upstate. It doesn't make sense. That's a business practice model that has been changed. But much like student housing, which is also feeling the burn here, students get grants all the time. And their parents want the grant money to go to the landlord so they don't blow it. And landlords have always adopted a policy of taking the money and sending it off to the landlord, paying in advance and marking it paid in full. And those landlords are frustrated by, how come I can't take the advance and apply it to my ledger? And so again, this comes down to a business model of, well, you can't ask for it, but if a tenant is offering it to you and you're crediting it to the ledger as paid in full, it's not deemed in advance, in my opinion. It is not something where you are insisting that it get paid. And again, this is not something that has been challenged in the law yet. Right now, it's written in no advances. And so from the perspective of housing or student housing or seasonals, it could be deemed in advance if you take it. But the flip side of that argument is if you don't take it and you turn the tenant away, what we did at Turning Stone event I did was we polled 300 people and we said, based on the lack of being able to take that security deposit, double security deposit, how many people did you turn away? And in 6 weeks' time, we had 310 people, tenants, who were turned away from housing because the landlord would not rent them without the security deposit. Well, if you can show from an economic development standpoint in Long Island or Adirondacks that you won't rent to people without a double security deposit or payment in full for a term, you're not going to rent to these people. What is it going to do from an economic development standpoint? You're basically taking the entire East End and trashing the business model.
Well, especially if you combine it with the fact that you can't do the background checks. And so all of a sudden you're saying, oh, here, take my $5 million house
Right.
and pay me monthly, but oh, by the way, I can't look into whether you're a shyster.
Right, right. So they're seeking clarification for 2020. I wish I had a concrete answer. What I will say is don't ask for it. You can't ask for the advance. So you can't put it in a contract where you say, you know, rent for 6 months is due and owing. But if in terms of this discount amount, what could be something that you do, and I'm seeing my clients do it, is if rent is due on the 1st and a late fee kicks in on the 5th, let's say. If rent is paid always on or before the 1st, meaning the date it's due, you could say that it's a $5,500 a month amount that's owed instead of, if rent's paid on the 5th, a $6,500 a month amount, which will entice them to pay on the 1st because they're getting that discount. I have seen that go into effect.
Is there any reason that all months within the lease have to have the same rent? Or can you charge the first month rent at X and the subsequent months at Y, Z?
So reading between the lines, the rent definition is the base rent for the use and occupancy. So you would just have to show a legitimate business reason for why the first month's rent is more than the rest of the lease term. What you could say to the effect of, well, from an administrative standpoint, maybe that first month is, you know, more administrative in nature, where you have to move in, do all the details to it, get tenants settled. Yeah, I don't know. It's a hard argument there because is the first month going to cost more than the rest? Yeah.
Well, Here, I think it's very easy to distinguish the months. It's historically, May is cheaper than June, which
Yep.
is cheaper than July, which is more, you know, and September, August is the most expensive.
That's a good point.
But I think that part of what Chris is asking is making me think, what about if in November, you say, I'm gonna give you 5 leases, one for May, June, July, August, and September, and you sign all of them now and pay all the rent right now. Can you do that?
You're not supposed to accept rent under the new law until it becomes due and owing. So,
5 separate leases?
yes.
But doesn't rent become due and owing on signing the lease?
It used to be. Now the interpretation is upon getting the keys to the property is what they're arguing.
Keys. Yeah, give them all the keys. Give them the keys for the property for all 3 months.
That's an idea. I would think then, yeah, but that problem is the access of the property, so they wouldn't be able to access it till the time the lease started. These are all great questions. This is what problem solving is how do you get around that? Now, in terms of what you're saying is create different leases for different dollar amounts. One way you might do it is month-to-month leases on dollar amounts that are all different. So, you could give them a stack of 6 leases, all of which are month to month, all of which have different dollar amounts. So the month of June, $6,000. The month of July, $10,000. The month of August, $12,000. And then if they don't pay their rent, you could, terminate that. The problem is the time to get rid of them will eclipse the next month coming owed.
Okay, so that solution is something I just used last week for rental for next summer. So how could that unravel on me? What could happen? Does the tenant go to court and say, what?
I don't think the tenant can argue that. I don't think there's a reason why you couldn't do that. It would just be a justification from a business model of why is April more than May, which is more, as the rent increases, justify the rent increase. Well, if you could show in the month statistical data, more people want to rent in the month of July, and the overwhelming increase of people and demand would warrant that higher price.
But you only have to show that it's a challenge, right?
Correct.
Right, so,
Correct. I don't think there's a challenge on that. I think you're fine doing it that way. It's just an administrative nightmare if they don't pay. Because then...
No, they pay when they sign the leases. So they signed 3 leases last week to cover their summer period.
Yeah, then you could take a security deposit off of each lease.
Exactly.
Yeah.
Exactly what we did.
Yeah.
Can you take the rent for each lease?
You're not supposed to take the rent, the way the courts have interpreted and the judges I've spoken to, they don't want you taking the first month's rent until they get the keys. But if they're getting the keys, then there's some justification. I think you can argue that.
There's 3 months.
You're not supposed to take it in advance. But again, what I've told clients is this is a business decision. And again, you have already an assembly member going to the AG and saying, change this. So it's almost like one of you would be remiss not to try this, to say, it's a business model, we have to take the rent to secure the property, and if that's deemed in advance, it is something that I would just document from a agreement with the tenant that you're not deeming it in advance and they're offering it.
What could happen to the landlord?
If it's in advance,
Well, if they violate,
under that section, I believe the Attorney General has discretion for $500 to $1,000 fines. And again, if they find that it's a pattern, they can introduce more. So, hold on one second. It's the GL sections. It's under General Obligations Law 7108. And I believe it's discretionary on the part of the AG. Yes, here, civil penalties, not less than 1,000, no more than 10,000.
Doesn't it say, I'm looking at the very last section.
Actually, sorry,
If a person is found to have willfully violated this section, the punitive damages of up to twice the amount of the deposit in advance can be...
Yep. Yeah. That's under the security deposit sections. Right. Can't pay their rent, being forced to be rent burden. This is not I can afford that $5 million seasonal rental that I can rent beyond my normal homestead and live there for the summer. And that messaging right there has to be this is not intended to protect the people living in the Hamptons for the summer. This is intended to protect the people who can't even afford Section 8 housing. And that is the difference. And again, I think that it is a contract. Your contract, first and foremost, on contract law dictates what happens. So if you have an agreement in writing that says all of what you just said, and at the end of it, it says, tenant acknowledges and has had the opportunity to seek counsel and waives anything. Now, there's certain things in here that say it can't be waived even if it's in the contract. But again, underlying legislative intent of who's this targeting? And it certainly wasn't targeting seasonal housing. And so with that in mind, with Fred Thiel coming in and saying, I'm going to put in legislation early in the legislative session and get this amended and revised so that it carves out seasonal housing, I don't think the Attorney General, I mean, this is my opinion, but I don't think the Attorney General is going to hammer a landlord here for doing that when it is very apparent it's not. Now, that's not advice to go do it because the law says it otherwise right now, but to me, from a lobbying standpoint and a practical standpoint, this was not the intended target of this law. And what I've been telling my student housing is if you are pro-offered monies and you know that that's the only way the tenant is going to be able to live there is if they prepay it, do not apply it and use it against the tenant for damages. Make sure it's applied as the ledger as a running credit, separate and aside. And that way you can show tenants just prepaying because they want to. It's not in advance. You're not seeking it. So again, it goes to the intent of arguing, we're not intending to make you pay this. It is being pro-offered. And so to your point of discounts, if you're putting it as an option, is it coercion to make them pay? I don't think so. I think it's something that it's like, okay, it's a sale. We all love to do sales, and you go to a sale and you buy something. No one's forcing you to buy it still. It's a sale item. And so that's the idea of the discounts. But it will be interesting to see, bless you, if a court interprets it otherwise. But for now, I think the month-to-month tenancies are your best bet if you're incrementing rents as they go forward. And I don't think that you will be challenged there because you don't have to give a reason. In the back of your mind with the HUD and then the New York State Division of Human Rights, that is something, again, those are all justified by your business models that the rent increases, and they probably won't be challenged by people like that.
My only comment on that is that you're never going to get somebody out of the summer.
No.
So it makes absolutely, to me, doing a month-to-month like that, what do you have? You've got somebody that pays the first month, the second month they don't pay. Now, if you're in the town of Southampton, you get before one of the 4 judges, you get that first adjournment, now you're a month into it, you're never going to get out. So,
These leases we done won't be paid.
oh, so they're all God's all right.
We would never,
Yeah, we got what I'm
expect to
saying,
pay
when you
this
talk about
summer.
month-to-month, like a month-to-month
Yep.
tenancy.
You're not.
Work out here.
Now, in terms of other potential avenues to get out of that, I mean, break lease agreements, that's another thing to use with tenants. I don't know if you guys have utilized that, which is if a tenant stops paying, what I'm seeing some of my clients say is, all right, we'll release you. So like say you're not using a month-to-month, you're using a 6-month lease, and in month 1 they pay, and then, I don't know, something happens, their roommates leave, they can't, pay the rest of the season, they've overextended themselves, whatever it is. To do a break lease agreement with them, which says, we'll let you on $2,000 or, in the Hamptons it may be $20,000. We'll let you pay that and be released from your obligations further so that we won't come sue you for the remaining portion of the money you owe. That's another option if they're, not paying you to get them out without having to go forward with an eviction is to do a discount break lease agreement. See if that works.
Would an escrow provision for prepaid rent be viable if it was with the attorney or maybe even with the broker?
Yeah, so that has been asked also. That appears to be contrary to the law. However, there are companies out there that are doing that with the security deposits where they're putting up bonds for the security and paying installments into that instead of security deposits, and that's a New York City trend. So I think people are trying to contract around that with those types of provisions. It is contrary in the wording The intent is another question. I think that's where we have to parcel it off of, really, is this violating what the purpose of the statutory section is, or really should there have been a carve out? And it could not be more clear from your own constituents in this area that they did not intend for it to be that. So, you could see from the bill that's being introduced, he's trying to make those concessions. With that in mind, hopefully 2020 won't be affected by it at all. There'll be something quickly that gets put into play, but for now, that still would be not allowable. As an attorney, I wouldn't want to take the risk of the escrow.
Well, we'll give it to the brokers.
There's passing that. Anybody else have any other questions? All right, so I want to just talk about briefly this move out inspection situation with you, making sure you understand now those processes. So when a tenant is contracting with you and signs a lease, there is right now an obligation for you before they move in, after they sign the lease, to do a move-in inspection where they would itemize exactly what's wrong or damaged with the unit. Then at the end of the tenancy, there's a notion that if they give you at least 2 weeks notice, that landlord on 48 hours notice needs to be able to walk through the unit with them and do a move out inspection. The problem here is that inspection has to take place no sooner than 2 weeks prior to them leaving, no later than 1 week prior to them leaving, which means that their items will all still be in possession of the property at the time this move out inspection is prescribed. And it's also New York law that you're not supposed to be moving their items when doing a move out inspection. So this is another area that we're lobbying to get reformed, which is to clarify that landlords will not do a move out inspection until the unit is free and clear, because what that triggers is the return of the security deposit from 14 days from the date that they vacate the property. Not 14 days from the end of the term, 14 days from the date they leave. And so this, for bigger property management groups, has been a nightmare, because turning around the security deposit, doing a walkthrough, assessing damages, how do you do that all within 2 week time span? And you have to give them an itemized statement for anything that you're deducting. And the only things that now can be deducted are your base rent, utilities that the landlord is paying for directly, normal wear and tear beyond a reasonable amount, and your moving and storage costs. That's the only part of the law that landlords got in their favor, was this moving and storage costs, which has always been something landlords had to sue for, now can come out of this security deposit. And what's this going to do? It's going to lead to a ton of plenary actions in small claims court. And the questions that I get here are, can we predetermine what those damage costs are? Can we create an itemized list? There was an attorney in Albany who wrote an article at, I believe it was the Times Union, who argued, no, you can't. You can't predetermine costs. And my opinion on that is, why not? If you have a business receipt that shows the blinds in your unit are $35 and they come from Home Depot and every unit has them, why can't you know what the cost of that is? Some things you'd have to call a contractor in, but some things would be able to be predetermined, that could be part of the lease as an addendum, that tenants now know what does it cost. Same thing with things for cleaning. It could be that it's predetermined when your workmen go in that to clean a greased up stove or a microwave, it's about an hour. $35 an hour you charge, whatever it is. Those are things that you could predetermine so the tenant knows they have a breach right they can cure before you walk in and do another inspection. So those are things that are frustrating also, that clients are finding that they can't do their property the way that they want to do it any further. Any questions with that? Okay, I'm going to spend about a couple of minutes on manufactured home parks really quick, and then I'll take questions if anybody has them. The major overwhelming sweeping changes for Part O, which applies to 233 for the manufactured home park housing, what it did was it limits now the increases of rent. I want to make sure we're not remiss that right now, pending legislation for the good cause eviction from Julia Salazar's bill is a continuance. She is intending on bringing it back to the state of New York in the legislative session, which would make everybody subject to universal rent control in the state of New York. And so that would look like a 1.5% increase with a CPI cap, basically making it a 3% increase on all rental properties in the state of New York. This is exactly what happened in manufactured home park housing, that there is now a cap at 3% on increases with an allowance for an additional 3% if the owner can show that there is justified manufactured home park operating expenses, that the property tax is increased, or that there is capital improvements in the property, or a regulatory agreement which allows for such increase. The tenant at any time, if there is an increase of 3% or more, can challenge that increase amount, but they need to file it within 90 days of receiving the notice that there is an increase going to be charged. Rent is also, again, defined to include all costs and fees. No exception for third-party pass-through here, so any additional amounts cannot be charged as rent. A lot of clients, when this changed into effect, their late fee dollar amounts or their utility costs, things like water, they were freaking out because if they were going to charge the water in the rent, it would jack up the rents over the 3% amount. And so a lot of my clients chose to just say, all right, I'll charge water as additional rent so that they can sue for the full increase of the dollar amount for those utilities. So that is something we've seen go on. Lease offerings here, there is the good standing provision that used to be in effect has been removed. So all tenants have to be offered a lease regardless of what standing they're in. If a tenant is not offered a lease, you cannot increase the rent, and there's other potential penalties. The lease offerings now need to be including a rider from the Division of Housing and Community Renewal. For anybody who practices in manufactured home park housing, you will know that the rider came out the day before leases were to be put in the mail this year. So I had a ton of clients who had mailed hundreds of leases by certified mail and out into the mail, big, thick leases that cost a lot of money, and they went ahead and they used the community rules and regulations that were up on the website from the Attorney General because HCR had yet to give this document out, and then when HCR did give the document out, there was a mass confusion about Section 2 on that document. So if you work in manufactured home park housing, you will know what I'm talking about there. But they did take forever to issue that rider, but the rider does need to get attached to all leases. Evictions of month-to-month tenants without cause is prohibited. Now, is this forecasting what's going to happen to the rest of the eviction world? Potentially. This is what was eventually ruled against last term. One of the other senators had put in a provision that said a without cause or with cause bill. We don't know if that will be resurrected again as part of Julia Salazar's bill, but basically what that would mean is all these month-to-month tenancies that you don't need to give a reason why you're terminating them. Going forward, you would have to have a reason, and it would have to be for things like non-payment or they weren't complying with the rules and regulations, and it would be very strict based on what the curative provisions of those were. So that's something that is going to handicap the manufactured home park world, and hopefully it stays there. Rent-to-owns, which were highly scrutinized and not looked favorably upon. Now there's an entire provision which basically details that the owner has to have title and proof of ownership, and in order to enter into these contracts, they have to show that. And then there's a whole host of statutory guidance now giving what needs to be done in those contracts. But the good news is, in terms of Dodd-Frank and the text of this, they are not outlawed by the state of New York anymore. Right of first refusal has been modified. It's applicable only to a change in use going forward. Here, attorney fees may be demanded if the fees are ordered by the court, so same thing as the rest of the RPEPL 713 or 735, section. And late fees. Here, late fees may not be compounded or considered additional rent in manufactured home park housing. So those things are all rolled into the rent, and so you can, in a manufactured home park, demand that, but you can't additionally seek them outside in plenary actions. And those are the overwhelming sweeping changes to manufactured home park housing. Any questions? We are right up against the time frame, but I will stay if you guys have questions. Thank you. I hope this has been helpful. A lot of my frustration is answering I don't know, or I think, or it could go this way. Truth of the matter is the laws are still so fresh, so new, and there's not a lot of case law. Trial by error works to a certain point. I always tell my clients, I'm going to lead you with some direction, but know if you have a business model and you can justify why you're doing it, and you can look at it from the tenant's perspective and show it hurts them as much as it hurts you, or it hurts tenants looking to rent seasonal housing and frustrates the purpose, then you've got a leg to stand on from an argument of applicability and did this actually intend to reach to that, because there's no legislative history, again, that we can drive down and argue against. So it's really crafting arguments for amendments, and that's where we need your help and your text of the language you need to see put into place for your seasonal. So I welcome anyone who wants to work with us to try and give us some language to help reprieve, or your frustrations, let us know what they are so we can definitely push home that argument for you in Albany. Thank you.